Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law office of Rajiv S. Khanna, PC. This is our bi-weekly community conference call every other Thursday at 12:30 p.m. Eastern Time. Um, when you log in to the call, you hear about the terms and conditions of the call. No attorney-client relationship established. This is basically just information for the community. I'll run through the frequently asked questions first. Then I will start on the questions that are not so frequently asked. We will not have time for any new questions today. We have enough questions. I may not have enough time to do any new topics. If you have posted a question or if you have a follow-up on a posted question, we'll be able to deal with it. Let's go to the first frequently asked question. This question is from Chaitanya, who says, I'm in the fifth year of H1B. Husband is also on H1B I-140 approved. I would like to move to H4 EAD. Can I convert back later on to H1B? And the answer is of course. You can always convert to H4 EAD and then convert back to H1, and you will not be under the quota. This is quite clear. So if you convert to H4 and you use your EAD and you want to convert back to H1, if to begin with you were counted on a quota H1, you continue to be exempt from the quota unless you have been physically outside the USA for 1 year. Then situation is a little different. So, okay, folks, anybody has a follow-up question on this, only this issue, press *5. Nothing new, no other issues. Any follow-up on this, *5. Okay. Let me go on to the next frequently asked question. The question here is about L1B who converts to H1B, and how does the change of status work and how does the quota work? So let us begin. Working for L1 for company X on L1B, Y company are doing an H1B in April. Number one, is my H1B petition within the limit of the H1B quota? I'm not sure I understand that question. I am guessing what you're asking me, Raju, is that because I have an L1, does that exempt me from the H1 quota? And the answer is no. I think that's what you're asking me. A bunch of people are just logged in, guys. No time for new questions. I'll be able to do only follow-up questions and the posted questions. No new questions. Sorry about that. So going back to Raju, so I think what you're asking me is if I have an L1B, am I exempt from the H1B quota? The answer is no. You are still subject to the H1B quota. When I get picked up in the draw, does my visa status change from L1B to H1B? We have actually discussed this issue several times, and this is a very interesting issue. Let me explain to you how it works. When you file an H1B, you are asking the government for two things. One, you're asking the government to determine you eligible for H1B. So one part of the petition says, here is Raju, he's entitled to an H1B. The second part of the petition is where you ask for either a change or an extension or a transfer. So the second part of the petition says, I'm on a student visa, or I'm on an L1 visa, or I'm on H4 visa. Please change me to H1B. So two components. One is determination of eligibility. The second is the actual change, whether that change is change of status or extension or transfer. So there are two components to it. You can actually separate the two. So when you are on L1B, you can file an H1B without requesting change of visa, without requesting change of status. So your petition will say, hold me eligible for H1B. When they do that, as soon as you get the visa stamp, you are exempt from quota. Okay, so you can actually do this. File in April without requesting change of status. If you get picked up October 1st onwards, you can go get H1B visa stamping or apply again for change of status to H1B. So you can separate the two. Question number 3. After changing my visa from L1 to H1, if I want to continue with X company on L1B visa, what do I have to do? Well, you have two choices. One is to go outside USA, and if your L1B visa stamp is still valid, just return to USA using your L1B. You could go to Canada or Mexico if you like. Okay, if you show the L1B visa at the airport, you are converted back to L1. Or you can file a change of status. If you have indeed received change of status to H1B, you can file change of status back to L1B. In October 2017, if I want to change my status from L1B to H1B, what do I have to do? I just explained that. Okay, folks, any follow-up questions on this issue I just discussed? Press *5 on your telephone. Nothing new. Any follow-ups on this issue? I've got one. Any other follow-ups on this issue? Okay. All right, go ahead, please. You are unmuted. Go ahead, I can hear you.
Hi, Rajuji. Good afternoon, good morning. So, what I want to know here is just basically, I want to have an option of H1B even I'm working on L1, so that my draw now currently is picking up in draw. So this year, if I pick, so that next year I can convert to H1. So I got that information. So is there any legal issues with this? I'm not sure. I'm new to this.
Yeah, there is no legal issue, Rajuji. The way it works is there is some problem with the quota counting. I'll explain that to you. If you are outside USA or if you have not requested change of status, you got your H1 approval, USCIS considers you to be exempt from the quota if change of status was requested. After October 1st, you are exempt from the quota. But if change of status is not requested or you are outside USA, until you get the H1B visa stamp, they don't consider the H1B to be completed. So they can still say you are subject to the quota. I think this law or this policy or this interpretation is highly suspect. Nevertheless, that's what they have been telling us. So somewhere along the line, you should go get your H1B visa stamp when you're ready to work. There is no limit on how soon you have to go. Okay?
Thank you, Rajesh. So in that case, when I'm applying for this, I should not go for COS as soon as when applying 2016 H1B quota. So that way, I will have L1 status, and after picked up my in the draw, I can change the COS. Is that fine?
You can change doing change of status COS, or you can go get visa stamping. No problem. Either way.
Okay. So that is only one thing. So when I'm applying, this will not known to my company. Is that correct?
They should not. No, I don't see why they would and how they could know. No, they will not.
Okay. Thank you very much, Rajesh, on this.
You're welcome. Good luck.
Thank you so much. Bye.
Raju has become quite the technical guy. It says COS, not change of status. I know most of us, when you spend time with immigration law so much, you become half immigration lawyers yourself. Okay, let's go on to the next frequently asked question. This one is from Sunil Suthar. He says, this is about H1 duration through a new employer after I-140 has been approved, then starting a new green card, and also do job titles and job descriptions have to match. So let me tell you, generally speaking, first of all, this is kind of interesting too. So let us say I'm in my 7th year of H1. Now my I-140 got approved. I'm entitled to 3 years. I got my 3 years of H1. I stayed with that employer. Now I'm in 8th or 9th year. So I have 2 more years left on the 3-year extension I got. Now let us say I want to change employers. First question is, when I change employers, can I get another 3 years? because I have an I-140 approved, even though it is for a different employer? And the answer is theoretically yes. As a practical matter, USCIS is a little inconsistent in these circumstances. How are they inconsistent? Sometimes they give you the entire 3 years of the I-140, sometimes they give you for that extension only the time that is remaining of the 3 years. So if you have 2 years left, they'll give you those 2 years. Although we have fought for it and we have gotten 3 years in most circumstances. So that's the first part. Can you get an extension through another employer? No problem. How long would you get it? I think you're entitled to entire 3 years. USCIS could try to roadblock you, but I think you have good argument for getting all the 3 years. Okay. So let's just read the next. Oh, starting a new green card. When you start a new green card through a new employer, folks, a lot of people have just logged in. Um, I just want to remind you folks, I will not be able to do any new questions today. I have a lot of questions on the table already. So no new questions this time, only the questions that are posted and follow-ups. Okay, follow-ups on the posted questions. Sorry about that. So going back to your situation, Sunilji. Um, when you start a new green card after you have moved over, the job titles, job descriptions can be completely different. I have explained this many times. Moving over to a new employer can be done one of the two ways. One way, you only carry the priority date forward, which is your I-140 is approved, 485 is not yet filed. You just want to carry the priority date forward. Here, the job descriptions do not have to match. You could go from being an IT professional to a chemist or a physician. Totally different H1, totally different green card. You will still carry your priority date. No question about it. This is quite clear. Second way you carry a green card forward is through AC-21 portability, where your I-140 is approved, 485 has been pending 180 days. Now when you change jobs, if you get same or similar job, you don't have to start the green card all over again. You can carry the green card forward. So remember the difference. When carrying only the priority date forward, you don't have to have same or similar job. When carrying the entire green card forward, you have to have same or similar job. Let me go to your questions and make sure I have answered all of them. I already answered the first question, how long will I get my H1B for? If I continue to stay with the employer B for more than 3 years, can they use approved I-140 from employer A for H1 extension? Yes. Under the current regulations, if the I-140 is not revoked, it can be used by any employer at any time for ongoing extensions. Under the new regulations which are being considered right now, and I have a blog entry on that, I'll show you where it is. If you go to immigration.com and scroll down on the right hand side, there are my blog entries. And here it is, the proposed I-140 EAD rule. If you go to these proposed regulations, you'll see what the government is thinking of doing now is that they're making it clear, even if the old I-140 is revoked, you will still carry your priority date. And if the old I-140 is revoked after 180 days by the old employer, you will not only carry your priority date, you will also carry with you the right to keep on getting H1 extensions. That's what I remember from that regulation. So that may be the new regulation that would come out soon. Okay. Then the last question you had was, Sunilji, does my job title have to be the same, etc.? And the answer is not at all. And it should not be an issue whether you go from being an engineer to a manager. It's not a problem at all. The jobs can be completely different. Okay. Any follow-up questions on these issues that I have discussed? Press *5. Any follow-up questions? Press *5. People are still logging in. I remind you, I won't have time for new questions, just old questions and follow-ups, please, this time. Okay, no questions. Let's go on to the next one. This one dealt with reapplying for a B2 visa after denial and what is the importance of income, some of the issues here. So Antariksh Singh says, planning to invite my father and mother-in-law for my wife's graduation in May. both permanent residents. I'm sponsoring them. We applied for their B2, it was denied under 214B, which basically just means that we don't know if you're going to come back or not. Okay. Father-in-law's income could have been a problem because the visa officer asked about it. Small business income was about 150,000 per year, which was less than what is in his tax documents, around 200,000. Should we apply for a visa again right away? Okay, remember, this is an issue of local policies. It is not, there's no standardized law on this. Theoretically, there is no limit to how many times you can apply for a B2 visa. Many times, consulates have local rules that you can apply for a B2 visa if denied. The second can be applied again, but it won't be applied in person. It will be done through mail. Third one, after denial, would be applied um, only after a certain number of months. So they have these local rules. Double check on that. I don't see any problem with that. Okay. Is it important for parents to have a huge income, even if their trip is sponsored? And the answer is no. Really, for a tourist visa, there is no requirement that either they be sponsored or they have huge income. This is an overall determination of the consulate's level of comfort with whether or not your applicants, your parents-in-law have enough ties to India and enough motivation to return to India. And really, it's a judgment call. But if you think about it, what are ties? I mean, are you talking about immediate family? I can always come back and visit family if I move. It isn't like I'm cutting off my ties. Are ties to my property? I can always sell property. If I move to USA, I can always come back to sell property. Businesses can be sold, assets can be moved, liquidated, sold. So it really, this is a very strange sort of requirement in the law, but and it's very difficult to quantify it or to contain it in a box, a neatly packed box. Really, it's a judgment call. Idea is whatever the consulate thinks, that's what it is. They come to a judgment and then they try to kind of give it a name like 214B, but it really simply means they are not convinced that the parents-in-law have enough motivation to come back. Antriksh ji, if you are on the phone, press star 5 if you have a question. Any follow-up questions on this? Nothing new. Any follow-up questions on this issue I just discussed? Press star 5. I will not be, again, new people who've logged in, I will not be doing new calls today. I'm sorry. Just posted questions and their follow-ups. Okay, there's no follow-up on this. Let's go to the next frequently asked question. I think that's pretty much it. Yes, visas for starting a restaurant business franchise. Um, these folks ended up doing a paid consultation, so I actually went over that with them. I'll just briefly sum it up for people. When we are dealing with a restaurant business coming from India, other countries might have slightly different options. They might have options like E2 visa, treaty investor. Um, they might have options like H2B, which is for temporary workers. India doesn't have either one of those options. So if you are a restaurant business in India and you want to open here, you have to look at three levels of employees. Um, the executive or managerial level employees can come on L1A visas. People who have some very special knowledge of your recipes and the way you do business nationally or internationally potentially could come on L1B visas. Executive chefs who have degrees or equivalent experience and do some specialized management work within the catering or kitchen area could potentially qualify for H1B under um, executive chef category. Um, the staff that is skilled but not specialized may not be able to come at all if they are Indian citizens. But if they are citizens of countries other than India, there may be an H2B visa possibility. Frankly, I find the H2B visa a very difficult visa to work with because it has certain requirements about the temporariness of the job. And you have to go through the advertisements in the newspapers. So I actually spoke with these folks I know I've covered all their questions. I don't think they are here. If anybody here has a question about franchising when you come from India, press star 5. Anybody has a question on that? Star 5. Okay. Uh, the next frequently asked question is from UX341. Filing B visa to maintain status, H1 and H1 extension durations when I-140 is approved. When I-140 is revoked, time USCIS takes to revoke an I-140. Okay, this is also a frequently asked question, very important for people who, for example, get laid off unexpectedly while they're on H1 or L1 or any visa that requires employers' support and work. What they typically do is before the H1 status gets over, for instance, if I receive notice that I'm going to get laid off next week, I can immediately apply for a tourist visa or B1, B2 visa, same idea, to the government saying that, look, I've been laid off unexpectedly. I want to be converted to B visa. I remember this. These are all things that you should make clear to the government. I will not work illegally until I get back on H1 status, um, and I have enough money to support myself. I would like to stay here for a few months, look for a job, and of course, I will not start a new job until I get another H1 approval. Now, the interesting thing is there are some small complications here. While if you file your B visa or B status application while you are still in H1, you can continue to stay in the USA, not work, but stay in the USA until your B application is decided. Okay. Government may approve it, government may not approve it, but you could get 3, 4, 5 months waiting time on this. What if you find a job in the meantime and you want to convert to H1? The problem is only this. Government can only convert you from status to status. They can't convert you from status to status pending. So when you have a B request pending, you are still in status pending. That's called authorized period of stay. They cannot convert you from that to full status. So while your B request is pending, if you get a job and you apply for it, when that H1 is applied for, on the date the H1 is decided, if the B is not already decided in your favor, government will ask you to go outside for visa stamping, H1 visa stamping, before you can start working. And that's the only complication, which is not the end of the world, but something to keep in mind. Now let me go over this question. Let me make sure that I've got it all. Oh yeah, you had some other things. H1 and H1 extension duration when I-140 is approved. 3 years, I already discussed it, sometimes less than 3 years if you are leaving in between the first 3-year extension. When I-140 is revoked, time USCIS takes to revoke an I-140. They can take many weeks, but when the revocation does come, it is retroactive. So if I, the employer, request USCIS to revoke your I-140 and they receive the request today, they act on it 4 months later, they will backdate it to today. Okay, so that's the way it works. Now let's look at your situation. Situation 1, I-140 is approved, H1 good till 2017, 6 years are over by Feb 2015, would lose my job in a few weeks. And I just covered that issue when you can apply for a B2 and keep yourself from going illegal. I'm trying my company not to withdraw the I-140 for some time. Can I file an H1B extension with my company? The answer is yes. If an I-140 is still in play, and I have discussed the new regulations which actually give you even more rights. If the I-140 is still in play, you can get an H1 extension using an I-140 approved through any employer and get H1B extension through any other employer. There's no question about that. This is also quite clear. What would be the length of time for which I can expect to get my H1B extension for this next employer? And the answer I just gave you, it is uncertain. Best case is 3 years, worst case is whatever you have remaining on the current. But we have been able to get 3 years in most cases. What if I want to change to a third employer after I join the second employer? Um, you know what? This is also an interesting situation. So first employer, let's say you had 3 years of I-140, H-1B. You joined the second employer, you got another 3 years. 1 year later, you want to join a third employer, but in the meantime, the old employer has revoked your I-140. How much time will you get? Will you get any time at all because there is no I-140 in play? We've been able to get at least 2 years in these cases, whatever is remaining. It's a little dicey, but by that time, the new regulations might be in effect, which say if your I-140 is revoked after 180 days, you will forever have the right to keep extending your H1, even if the old employer revokes the I-140. And I've already covered how long does it take to revoke the I-140. Okay, now anybody has any follow-up questions on this? Press *5. Follow-up questions on this, *5. Okay, one only. All right, California, go ahead, please.
Hi, Rajiv. Uh, I had I had posted the question. Thanks for your reply. Um, the specific clarification that I request is that you mentioned that if my employer sends a request for revocation of the I-140 today, and USCIS gets it, let's say, 2 months later, they will make the I-140 cancellation effective from the date on which the employer sent the request, that is retroactively.
That is correct.
Here is my question. Like, let's say USCIS gets the document, or they act on the documents 2 months after the employer sends it to them by post or whatever. They act on the application 2 months later. In that 2 months of time, if I find a different job and that employer files for my H1B petition in premium, because the USCIS may not have acted on the application cancellation, I-140 application cancellation, I would probably get the H1B extension, right?
That is correct. And in fact, once the extension is given, as a practical matter, so far what they have done is even if the I-140 is retroactively revoked, they will not take away the H1 they've already given
you. Okay. They will not take away the H1B that they have already given.
That is correct.
Okay. And you mentioned that in the current, recent rule changes that are underway, there is a provision that if the I-140 is cancelled after 180 days of approval, then an employee can get multiple extensions, one after another, H1B extension.
I think that's what the regulation said. From what I remember, that's what the regulation said.
But that rule is not yet effective, so it's not of much help at this point.
Not yet, but it might be effective within a couple of months.
Sorry, what was the last thing you said?
I'm sorry?
No, I could not hear the last thing you said.
I said
the rule could be effective in 2 months.
Within a couple of months or so, 2-3 months, maybe 4, something like that.
Okay, so my I-140 was approved in 2014 in November. So let's say this rule gets approved in, let's say, 3-4 months. So they will apply to I-140 that was approved in 2014 November, right?
I don't know that. I don't know what the chronological coverage of the rule will be, but
okay.
I suspect they will cover existing cases. That's my guess.
Okay.
Okay.
Yeah, the question would be when the rule is approved, whether they will apply to I-140 is approved after that time when the rule is approved, or retroactively.
I have a few. My guess would be they'll apply to all the cases, even before.
Okay.
But I could be wrong. I'm just making a guess here.
Right. Okay.
Okay. You're welcome. Good luck, sir. All right. Let's see if there is any other frequently asked question left. Oh, yes. There was a question about political asylum. I am very sorry. Don't do asylum cases. I hope I didn't waste your time. Um, last time I did an asylum case was in 1993. So, and that was as a favor to a friend. I have never done an asylum case since then. In those days, we had to go to court because the case was denied. We had to appeal. So no, I don't know anything about asylums. You best talk with somebody else. Okay, let's start dealing with questions that were not frequently asked questions. Regular questions. From USA Desi says, look, I had an N400. Oh, I'm sorry, I had an N470. Now that I have come back, in order for me to take advantage of the N470 protection, do I have to continue keep working for the same company who helped me with the N470? And the answer is no. I do not know of any law that requires you to do that. Okay, so I do not know of any law that requires you to do that. Let me flow through all the questions that were posted, and then I'll or maybe I'll just invite. Do you have any follow-up questions on this? Please press *5. Follow-up questions on N470, *5. All right, none. Let's go on to, oh, there is one. Okay. Uh, Massachusetts. Go ahead, please. Massachusetts.
Hello?
Yes, I can hear you.
Rajeshji, good afternoon to you. Thank you very much for your quick answer. But I have always traveled once in 365 days. So I just wanted a reconfirmation about it that I'm quite covered. After 900 days, I can apply for my N400.
Okay.
This is USA Desi here.
Let us quickly review what N470 does and what it does not do. Okay.
Okay.
If you have filed N470, in order for you to meet the requirement of filing for naturalization, you still have to have, if you are married to a US citizen, 1.5 years. If you are regular case, 2.5 years of actual physical presence in the United States.
Okay.
So what N470 does is it prevents your clock being reset if you're outside USA for a year or more. So in your case, even if you had not filed an N470, you might have been okay with just a re-entry permit. But since you have filed it, not a problem. You have to still meet the requirement of 2.5 years of physical presence. And to the best of my knowledge, and 470 can get complicated. Sometimes I have to review the regulations again. But as far as I remember, you should be able to file for your N400 naturalization as soon as 2.5 years of physical presence are complied with. Okay?
Okay. And at that point in time, I need not be employed by the same employer. That was my fundamental question, which you said I do not have to be employed by the same employer.
To the best of my knowledge and remembrance, that's exactly what it is. You do not have to be employed. Okay?
All right. Thank you very much, Rajeshji. I appreciate your advice. Thank you very much.
You're very welcome. Good luck. Always a pleasure. Okay, there is a follow-up on this. Please make sure this is related. Otherwise, I won't answer because I'm not doing new questions today. So go ahead, Texas. Go ahead. Texas. Okay. I guess that's an error. All right, let's go on to the next question. That was a frequently asked question from Ram Shankar. My first ever US H1B visa stamping was 3 years ago. Both the visa and 797 expired recently. Never traveled to the USA. If I apply for a visitor visa, will that result in cancellation of my H1B permanently, or will I be still exempt from the quota? And the answer is the B visa does not interfere with your right to be exempt from the cap until 6 years have passed from the H1 approval duration. So if your H1 has been approved anytime within the last 6 years, you are exempt from the H1 quota. Okay. Ram, if you are on the phone, Ram Shankar, press star 5 if you have a follow-up question. Anybody has a follow-up question, press star 5 on this issue. You do not. Okay. Let's go on to the next. It's, oh, there is one. Okay. This is Connecticut. Connecticut, go ahead, please.
Hi, Rajiv.
Hello.
Yeah, I have one follow-up question on this. You talked about 6 years being on H1 and then stock reset. Actually, I'm due to go back to India in next week, and my employer actually didn't file my green card. Earlier, he was telling me he would file in advance, but due to budget constraints and all that, they didn't do that. So I have to go to India since my H1 6 years would be over. My extension also considering the extension period.
Hang on one
So
second.
I have a question
I'm sorry.
as per the rules,
I'm sorry. One second. One second.
complete 1 year
One second.
outside
One
US.
second. I'm sorry. I'm sorry. This question has nothing to do with what I posted. I'm not doing any new questions today. I'm sorry, guys. Next question is from, I announced in the very beginning I won't have time for new questions. Next question is TD3000. I'm trying to bring my brother to the US. He's a chartered accountant with many years of experience in Dubai. Can we get H1 for people who are not IT professionals? And the answer is yes. H1s are available for any job for which a bachelor's degree or equivalent in a specific discipline is required. So if you have a job that requires bachelor's in liberal arts, that's probably not a professional position because it doesn't require a specific degree. But if you have a job that requires a bachelor's degree in accounting or in geography or in history, that can go under H1 because it's a specific degree. So as a general rule, any job that requires a specific bachelor's degree or equivalent experience can qualify for H1B. For accountants, there is a special problem that you need to be aware of. Make sure the job being offered in USA is not the job of a bookkeeper, that it is a job of an accountant. There's a difference between an accountant and a bookkeeper. Okay, let your lawyers determine that and help you with that. But typically, bookkeepers' jobs don't require a bachelor's degree. Therefore, you cannot get an H1B for those kind of jobs. Okay. If you are on the phone or you have any follow-up question, press star 5. No new questions, please. I do not have time for new questions today. Any follow-up on this issue? Okay, let's go on to the next one. This is from Part Terp 385. I'm in 5th year of H1B. Wife is also on H1B approved I-140. Oh, she's got an approved I-140. I would like to move to H4 EAD. After converting to H4 EAD, if my PERM gets approved, I-140 gets approved, can I convert back to H1? The answer is yes, you can, because then you would have the right to get 3 more years of H1. I don't see any reason why you cannot do that. Yes, you can, even though your 6 years are over, because your I-140 got approved, now you have entitlement to 3 more years. Okay, that answers that question. Any follow-up on this question, press star 5 on your phone, please. Any follow-up on this question, press star 5 on your phone. Okay, next question is an important one, of course. The I-140 proposed rule change, when is that likely to become effective? We don't know. A few months, could be just a couple of months, could be more. Remember, typically once the rule is posted, after the posting period is over, there's still comments. And for instance, the STEM OPT rule that the USCIS published, there were more than 55,000 comments, and government has to address all of them. So some of this variable time period depends upon how many comments they receive. Some of it depends upon how many changes they are deciding to make. Typically, government doesn't like to make too many changes once they have published proposed regulations, but you never know. Okay. Any question on this issue? Star 5. Any question on the new regulations that might come out? Okay. No questions. Next is Brit 12345 is a college student, permanent residence, applying for citizenship, but there is a disciplinary record for violating school's judicial code. I'm protected by FERPA. I'm not an expert in FERPA. I don't know what it says, but let me tell you generically what the law is. It's very interesting. This can be quite a trap for people who don't know what is going on. I don't know about FERPA specifically, but let's take another example. Let's say a criminal conviction. Let's say I got convicted of shoplifting. Heaven forbid, but let's say it happened. I got convicted and I was just given a fine of $200 and a probation of 3 months, after which my record was expunged. Now, if the government goes looking for my criminal record, it doesn't exist. The question is, when I'm filling N400, and this happened just a year before I filed the N400, do I have to reveal that conviction? The answer is yes, of course. Okay, I do. Because immigration law says we don't care whether your conviction was expunged or not. Our question just says, have you ever been arrested? And if the answer is yes, you have to say yes, even if the record was expunged. Now, to the best of my knowledge, this will not extend to student records. I don't see why there is any issue of arrest there. I don't think any question on the N400 asks you about it, but I would want you to confirm that, have a lawyer go through your N400 with you. If you're not hiring a lawyer for the whole case, just make sure that you have somebody review the form for you. Okay. But I don't think this is going to be an impediment to your naturalization, simply because there is no question on the form N400 that asks you about student violations. If it did, you would have had to reveal it. That is my opinion. Star 5 if you have a follow-up question. Brit, star 5 if you have a follow-up question. Anybody has a follow-up question on this issue? Star 5. Okay. U visa. Better World wants to know, is it mandatory to wait 3 or 4 years before U visa holder can file for green card? I think the mandatory period is 3 years. I don't remember all the details off the top of my head, but I believe unless you held a U visa for 3 years, you cannot apply for a green card, and that's mandatory. Anybody here with a follow-up question? Star 5. Press star 5. Okay, that seems to be taken care of. Next question is Bala. Wants to sponsor visitor visa for his parents. Can I change to H4 once they get their visa approval? Why not? There's nothing in law that stops you from doing that. Should I be working by the time they travel here to USA? No law requires you to do that. Okay, so on both these issues, I see no law that requires you to either maintain H1 or to continue working. Press star 5 if you have any question, follow-up question on this. Star 5. Let's go on to the next one. This is from Gina245, who is a permanent resident for 7 years, but wants to study in Japan for 1 year. Did reapply for re-entry permit before she left. I'm back in the US. I want to apply for citizenship. Should I apply for N470? No. N470 has no application to your case. Okay. First question I would have, and I'm keeping my fingers crossed, is did you return to the United States within 1 year? Even if it was 364 days, if you returned you can actually apply anytime when your 2.5 years of physical presence becomes fulfilled, which is probably right now. If you have been outside USA for a year or more, then you can only apply after 4 years and 1 day from when you entered US. 4 years and 1 day. But if you were never outside for 1 year or more at one stretch, you can apply right now if you meet the physical presence, which is 2.5 years in the last 5 years. Okay, if you are on the phone and you have a follow-up question, please press *5. Anybody has a follow-up question, press *5 on this issue. Once again, I repeat it for you, Gina. If you have not been outside at a stretch for a year or more, you can apply right now if you meet the 2.5 years of physical presence in the last 5 years. If you've been outside for a year, but you had a re-entry permit, you can only apply after 4 years and 1 day, assuming that you maintained your 2.5 years of physical presence during that 4 year and 1 day time. Okay. Next question, asylum case. Sorry, I don't know anything about asylums. I already apologized for that. Then Rakesh had a PERM denial due to a typing error. What happened was, this is such ridiculous rules. I mean, typographical errors can happen anywhere, even in our own office. Even though we review the form, 3 different people review it. Even the employer reviews it, the employee reviews, we can still make mistakes. And for the dumbest typographical errors, they will deny the case. Here, they said country of citizenship USA. They denied the case. Okay. The problem is this, Rakesh ji. The appeal time is 3.5 years. It takes 3.5 years for the appeal to be decided. So, unless the case is corrected on a motion to reopen, reconsider, I think you'll be better off going somewhere else or starting the green card with the same employer all over again. You can do that as well. Okay. That would be my snap judgment on this issue. So difficult to decide which way things will go. Personally, I think this case will be approvable on appeal. That's my guess. But who knows? If you're on the phone, *5. Have any follow-up question, press *5. Rakesh, *5. Okay. Let's go on to the next question. Ram_law. I am on H1B with approved I-140. Priority date is June 2010. Want to change employers. Not sure if the current employer will withdraw the I-140 that's already approved. What are my options if my current employer withdraws the current approved I-140? So here is the answer to that question. USCIS, under the current way of thinking, and I have an entry on this on my blog. Once again, I've showed you where my blog is. You go to immigration.com, scroll down, and on the right-hand side, there is my blog, right-hand side. You go in there, you can read up on it. I've said that USCIS has flip-flopped on this issue. What happens if the employer revokes the I-140? They used to think you keep your priority date. Let me start with the current thinking. Current thinking is you keep your priority date, even if the old employer revokes the I-140. But there is nothing written on this. This is only a comment they made in one of the meetings they had with immigration lawyers. Okay? They have gone, can keep it, cannot keep it, can keep the priority date, cannot keep the priority date 2 or 3 or 4 times. Under the new regulations, you will be able to keep your priority date if the new regulations come into effect. Will they cover you? I don't know. Will they be passed in the form that they had proposed? I don't know. But it appears that you should be able to keep your priority date under the current thinking of USCIS, even if the I-140 is revoked. But you will not have the right to extend your H1 based upon a revoked I-140. Okay. However, the new regulations would allow you to do so, even extend H1s, if the I-140 is revoked after 180 days. Any follow-ups on this? *5, please. *5. if there are any follow-ups on this. Okay. Next question is from Lakshmana Charyulu. Lakshmana Charyulu, who wants to know, is there a limited number of times we can apply for H1B, like only 2 times? The answer is no, no, no. You can apply as many times as you like. There is no limit, 1 to 100, 1000. No limit to how many times you can apply for H1B, as long as you do it within the limits of the law in the sense. If you have no way of extending it beyond 6 years, you can't file again until you become eligible again. But within those 6 years or extended 6 years because of green card, you can file as many H1s as you like. Any follow-up question on this, please press *5. No question. Guri has a question. Guri, you had posted your PERM denial, and I deleted that because I think that's a violation of your privacy. I didn't want that to fall into anybody else's hands. So I did review it, but I deleted it. So, but I don't remember the details because whatever I need to know is really in your message itself. Try not to post any of your documents, guys. That's a very bad idea. Okay. So your PERM got approved in 2010. This is a strange case. But then you got an audit on an approved PERM in 2011. That's very, very unusual. Unless the audit came from USCIS, I don't think Department of Labor goes back and audits its own PERM. So the PERM got denied because the employer did not advertise this position. Well, there is no sympathy basis for carrying forward the I-140 priority date, Kuri. The way it works is, if the I-140 is approved, you can carry your priority date forward. But if it is revoked for error or fraud, you definitely cannot carry it forward. This looks like error. So that I-140, which was erroneously approved, is a non-entity. It doesn't mean anything. So you cannot take any benefit from it. Of course, if you filed an appeal against that denial, and I'm assuming that's an I-140 intent to revoke and denial, it is not a PERM audit. I don't think that would happen. But in either case, you should be entitled to an appeal. And while the appeal is pending, you can keep getting H1 extensions. Keep this in mind. Okay. *5, if there's a follow-up question on this. *5, please. *5. Okay. Next question is, I have a B2 visa for 10 years from 2015. I visited USA in 2015 and then came back. Can I enter USA on the same visa for business visit? Tough question to answer. I think you can, but I don't want you to. I want you to send an email to the consulate, and consular website should have non-immigrant visa sections email. Explain to them your circumstances. Even go as far as, if they don't respond, go as far as actually making an appointment for a new visa based upon business reason. And chances are they'll tell you you can use the same visa. But I think it's important for us to disclose that our intention this time is not just tourism, but to actually have a business purpose in mind. Okay. So I would like you to do some due diligence. Keep documentation that you followed up with the consulate. And if they let you use the same visa, great. Okay. I would like to set up a business. Can I register and set up business while on visitor status? And the answer is yes, but be careful. As long as you are not actually doing business, if you're just setting things up, that is allowed. Shaking hands, meeting with a accountant, hiring lawyers, getting your process started, but don't actually do business on B1. You're not allowed to do that. You can enter into contracts. Okay. Can you register? Can you incorporate? Sure. I don't see any problem with that. What documents do I need to show to the officer at the port of entry? I don't think you can have any documents because you haven't even registered anything yet. By the way, you may be able to register businesses even outside USA. There are professional incorporation companies See, incorporation in India and incorporation in USA is quite different. Indian incorporation is painful. Even closing the company down is very painful. Indian Companies Act, as I remember, is procedurally very complex. In USA, places like Delaware, you can open a company in 20 minutes over the telephone. Okay. And similarly, you can close a company very quickly. Okay. So that said, you can register while you're here in the US on a visitor status. I don't see any problem with that. And I've answered the rest of the questions. Any follow-up on this, please press *5. Any follow-up on this, press *5, please. Okay. So this one is a little lengthy. Vishal Pratap says, I worked on L1B from 2011 to 2013 with company A. H1B was filed with B in 2013 April. Got approval from October till September 2016, but got change of status also. Could not join company B, never worked, came back to India. In March 2014, went for visa stamping, but got 221G and finally revocation. So then another case was filed, which was denied because of specialty occupation. So we've got one case revoked through the consulate, another case denied for specialty occupation problem. Now company A wants to transfer and file for H1B. This is the very first company for whom you were working on L1B. They feel that you are cap exempt. See, I don't know how you would make that argument. Because if the H1 is revoked by the consulate or through the consulate, I think you are back being cap subject. I'll have to look up the law on this, but my instinct or my first guess is, educated guess is, you are not exempt from the H1 quota. Okay, that actually answers all your questions. Do you have any follow-up question? Press *5. Any follow-up question? Press *5. Okay, one question. Let's see. Okay, Vishalji, is that you? Go ahead, please.
Hi, Rajiv. Can you hear me?
I can hear you very well.
Yeah. So one particular question. So like you've already answered that I'll not be cap exempt and I'll be cap counted. So I'll have to file a fresh H1 and cap. Now, what the company was saying is that if you've even worked for some time in H1 and then your petition is revoked, then you are considered cap exempt. But if you've never worked on H1 and then petition is revoked, then you'll not be considered cap exempt. Is it correct? Or
I personally think if your petition is revoked ever, I think you go back to being cap subject. I could be wrong on this. I would have to double check with USCIS on that. But I think if the petition is revoked, it becomes a non-entity because it has been revoked for an error, that it should not have been approved at all. So I do not know, but my guess is that either way, whether you worked or not, your petition revocation operates as a nullification, putting you back in quota. But if you have never worked for that employer, never got a visa stamp, that makes even a weaker case.
I see. And the reason why the second employer in which the petition was denied, that was accepted is because till that time the first petition was not revoked. Am I correct?
That is correct. Yes, sir.
Okay. Okay. All right.
All right.
Thanks for your.
But do have this followed up. Let your lawyers do some more due diligence. See, law is never this simple that you can make an educated guess and know for sure that you're right. I still, after almost 30 years of practice, I go back and read the regulations and reread the regulations, my own notes, government memos. You have to constantly do that. So let's just have your lawyers double check this. But this is my instinct. Okay.
Yeah, because in this issue, I have got mixed answers, and some people have said that it's cap exempt, and some of the cases which I've seen personally, they have applied and they have, some have got cap exempt and approved in the same case, and one or two cases I know have been denied. They got an RFE saying that it should not be a cap exempt case, and finally a denial notice because of that. So I was a little confused, and I thought of putting the question across to you.
Well, I will clarify something for you, which has actually bothered me for the last few days. Government, unfortunately, is only as good in its adjudication as the officer who's deciding your case. And it is not necessary that the officer knows the law. Okay. They are trained, but immigration law is so complex that they could be completely unaware of the issue presented and make the wrong decision. I am aware of many wrong decisions. Okay, so the fact if somebody escaped the quota, was that the right result? It's doubtful. Can it be equally attributable to government error? Sure. Can I be wrong? Absolutely. I will readily confess it. Some issues I know black and white, I can tell you. So don't rely upon other people's experience that could be attributed to many different things. Okay.
All right.
Good luck.
Okay. Thank you.
You're welcome. Okay. Let's go on to Peter Pelk. What is your estimate of the current prevailing wage determination processing time? How long does it take? Let me check. Sumanji, how long for prevailing wages these days average? 12 weeks. Okay, thank you. So yeah, you are right. 12 weeks is about 3 months. So PERM processing, again I'll call it. Sumanji, how long for PERM processing average? 7 months. Thank you. Yes, sir, your information is correct. And by the way, we do keep the current times. If you go to our website and go to the footer, under common topics, you will see processing times and status checks. Click there. We keep everything updated. And here is the PERM processing dates. Okay. You'll see historic data as well as current data. It's right there. Okay. Any follow-up questions on this issue? These are simple issues. Any follow-up? Press *5. No issue. Okay. This was frequently asked question. I've already done that. And this is the last question of the day, folks. And we're already out of time. I knew I didn't have enough time for new questions today. Best way to get your questions answered is just post them. Because Monica or one of the other team members will open a thread, I think tomorrow. You can post your questions there. And normally they close the thread between 20 and after 20 and 24 questions, between 20 and 24 questions. When it's 24, I know I'm not going to have enough time. When it's closer to 20, I know I'm going to have some time to answer your questions. So just post, and you can log in using your Facebook or a Google Plus account, or just make an account right there in our forums. It's instantaneous, and they will always remain free. We never intend to make them any payment kind of stuff. So just do it through that. Okay. So the last question is from Jitu. He says, I'm on L1A, completed 4.1 years. They haven't started my green card. If they do EB2, and then I complete my 7 years in L1A, do I need to leave USA or can I keep working? It's a very interesting question. I don't know the answer to this question, actually. I know this, even if there were 3 days remaining on your L1A and your I-140 got approved, I think you have some right to get an H1 extension for 3 years. But this is one of those areas of law where I don't have a clear answer. I would have to do a lot of homework on this. Tell your lawyers to look into it. I don't know if you can get 3-year H1 extension even after 7 years of L1A have expired. My guess would be yes. But it's an important issue. I would not want to make a dumb guess and end up being wrong and causing you problems. have this double checked. If I find a new job, they process my H1B, and I can start working only in October. By that time, 5.6 years will be over. Can the new employer file green card? They can file a green card even before you join them. So, you know, you don't have to. They don't have to wait until you actually join them to start your green card. Of course, they can start after you join them, but they can start even before that. Is there any condition green card needs to be filed 1 year prior to the current visa? No, not at all. Even if you have to leave USA while you're in India or Philippines or China or Australia or New Zealand, another employer, an employer in USA, one or more employers can start your green card even though you're outside US. Okay, this was the last question, folks. Any follow-ups on this? Star 5, please. Star 5. Any follow-ups on this? There it is. I guess it's Jitu. Sir, go ahead. You're from Texas. Go ahead, please.
Yeah. So, like one person, like suppose a new employer filed a green card, but like this is the last year and there will be lottery, right? Most of the time it will be lottery. So he's not sure like whether I will be coming in the lottery or not, right? So that is one of the questions.
That is definitely a question. Just because you are entitled to 3 years of H1 extension doesn't mean you are exempt from lottery. Okay, so you're still subject to the lottery rules, but you are entitled to 3 years of H1 if the I-140 is approved before your L1A expires.
Okay, and like suppose like I am working for 10 years and they file like my green card in EB2. So in between, like I got a job from a different employer and they filed the H1, but the petition got denied. But I don't have a copy of that petition. So do I need that copy of petition also, or
no?
I'll see the petition or not needed?
I don't see any need for it. No, sir.
Okay.
Okay.
And like yeah.
Did you have another question?
Yeah, last question. Like,
please.
Like, I got a extension for 2 years. So like, suppose I usually completed 4.5 years, and in next 2 years I will be completing 6.5 years. So I can extend my L1 for another 6 months, right?
Yes.
If suppose I don't extend it and I go to India, I be there for 1 year and come back. So I have 6 months pending. So can I use the same petition or they need to file a fresh petition for me?
If you left USA after 6.5 years and you stayed out for 1 year, you now have entitlement to get 7 more years of L1A.
So it will be a same petition or they need
no,
they
should. Why would they want to file the same? They should file a new petition. Get you 3 years of L1A.
Okay, so I cannot use the same petition even if 6 months pending, right?
You would not be able to if you do the math. If you left USA, let's say you have 1 year remaining, and you left USA, and you were 1.5 year. You had 1.5 year remaining. You left USA and you were outside for 1 year. You are entitled now to 7 years, right?
Right.
Can you use the 6 months from the 1.5 years that you had before? Yes, you can. That's my opinion. And then when you do the next extension, you are still eligible to receive, I would say, that's an interesting question. I think you will still be entitled to your 7 years of H1. That's my guess.
Yeah, because my current petition, like whatever.
But you know what? Hang on, Jitu. This is such an academic debate. If I were the lawyer, I would not even take a chance. Remember, I'm not a college professor. My job is to find practical solutions, right? I'm not a theoretical guy. I would file a 3-year extension before I bring you in anyway, because that way I remove any doubt whether you can use those 6 months or not use those 6 months. Just get you 3 years. You are good for the next 3 years.
So only like issue I have, because if like I have 6 months pending, I'm going there. So if I can't use the same petition because my current petition is individual, and if they file the new petition, it will be blanket, and there is more chance of getting the blanket rejected than the individual. So
there's no question. There's no difference legally between a blanket and an individual L1 for somebody like you. I don't see how that makes a difference.
Okay.
Okay?
Okay, thank you so much, sir.
You're welcome. Good luck, sir. Okay, folks, I will see you again in 2 weeks. And I'm always unhappy when I cannot answer new questions. But we are already 1 hour and 10 minutes into this call. So I also run out of steam after about an hour or so. We'll talk about your issues again in 2 weeks. Please post them on our forums. That way, I'll be sure to get to them. Thank you for this opportunity to speak with you all. I really enjoy it, and I'll talk to you soon. Bye bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and you know, it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.